Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Property Law, Title 7, Easements of Servitudes. Chapter 1, Easements in General. Section 1, Different Kinds of Easements. Article 613. An easement or servitude is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to a different owner. The immovable, in favor of which the easement is established, is called the dominant estate, that which is subject thereto, the servant estate. Article 614. Servitudes may also be established for the benefit of a community, or of one or more persons, to whom the encumbered estate does not belong. Article 615. Easements may be continuous or discontinuous, apparent or non-apparent. Continuous easements are those the use of which is or may be incessant, without the intervention of any act of man. Discontinuous easements are those which are used at intervals, and depend upon the acts of man. Apparent easements are those which are made known, and are continually kept in view by external signs that reveal the use and enjoyment of the same. Non-apparent easements are those which show no external indication of their existence. Article 616. Easements are also positive or negative. A positive easement is one which imposes upon the owner of the servant estate the obligation of allowing something to be done, or of doing it himself, and a negative easement that which prohibits the owner of the servant estate from doing something which he could lawfully do, if the easement did not exist. Article 617. Easements are inseparable from the estate, to which they actively or passively belong. Article 618. Easements are indivisible. If the servant estate is divided between two or more persons, the easement is not modified, and each of them must bear it on the part which corresponds to him. If it is a dominant estate that is divided between two or more persons, each of them may use the easement in its entirety, without changing the place of its use, or making it more burdensome in any other way. Article 619. Easements are established, either by law or by the will of the owners. The former are called legal, and the latter voluntary easements. Section 2. Modes of acquiring easements. Article 620. Continuous and apparent easements are acquired either by virtue of a title or by prescription of 10 years. Article 621. In order to acquire by prescription the easements referred to in the preceding article, the time of possession shall be computed thus: in positive easements, from the day on which the owner of the dominant estate, or the person who may have made use of the easement, commenced to exercise it upon the servant estate; and in negative easements, from the day on which the owner of the dominant estate forbade, by an instrument acknowledged before a notary public, the owner of the servant estate from executing an act which would be lawful without the easement. Article 622. Continuous non-apparent easements and discontinuous ones, whether apparent or not, may be acquired only by virtue of a title. Article 623. The absence of a document or proof showing the origin of an easement, which cannot be acquired by prescription, may be cured by a deed of recognition by the owner of the servant estate, or by a final judgment. Article 624. The existence of an apparent sign of easement between two estates, established or maintained by the owner of both, shall be considered, should either of them be alienated, as a title in order that the easement may continue actively and passively. Unless, at the time the ownership of the two estates is divided, the contrary should be provided in the title of conveyance of either of them, or the sign aforesaid should be removed before the execution of the deed. This provision shall also apply in case of the division of a thing owned in common by two or more persons. Article 625. Upon the establishment of an easement, all the rights necessary for its use are considered granted. Article 626. The owner of the dominant estate cannot use the easement, except for the benefit of the immovable originally contemplated. Neither can he exercise the easement in any other manner than that previously established. Section 3. Rights and obligations of the owners of the dominant and servant estates. Article 627. The owner of the dominant estate may make, at his own expense, on the servant estate any works necessary for the use and preservation of the servitude, but without altering it or rendering it more burdensome. For this purpose, he shall notify the owner of the servant estate, and shall choose the most convenient time and manner, so as to cause the least inconvenience to the owner of the servant estate. Article 628. Should there be several dominant estates, the owners of all of them shall be obliged to contribute to the expenses referred to in the preceding article, in proportion to the benefits which each may derive from the work. Anyone who does not wish to contribute may exempt himself by renouncing the easement for the benefit of the others. If the owner of the servant estate should make use of the easement in any manner whatsoever, he shall also be obliged to contribute to the expenses in the proportion stated, saving an agreement to the contrary. Article 629. The owner of the servant estate cannot impair, in any manner whatsoever, the use of the servitude. Nevertheless, if by reason of the place originally assigned, or of the manner established for the use of the easement, the same should become very inconvenient to the owner of the servant estate, or should prevent him from making any important works, repairs or improvements thereon, it may be changed at his expense, provided he offers another place or manner equally convenient, and in such a way that no injury is caused thereby to the owner of the dominant estate, or to those who may have a right to the use of the easement. Article 630. The owner of the servant estate retains the ownership of the portion on which the easement is established, and may use the same in such a manner as not to affect the exercise of the easement. Section 4. Modes of extinguishment of easements. Article 631. Easements are extinguished. 1. By merger, in the same person of the ownership, of the dominant and servant estates. 2. By non-user for 10 years. With respect to discontinuous easements, this period shall be computed from the day on which they cease to be used, and with respect to continuous easements, from the day on which an act contrary to the same took place. 3. When either or both of the estates fall into such condition that the easement cannot be used, but it shall revive, if the subsequent condition of the estates or either of them should again permit its use, unless when the use becomes possible, sufficient time for prescription has elapsed, in accordance with the provisions of the preceding number. 4. By the expiration of the term, or the fulfillment of the condition, if the easement is temporary or conditional. 5. By the renunciation of the owner of the dominant estate. 6. By the redemption, agreed upon between the owners of the dominant and servant estates. Article 632. The form or manner of using the easement may prescribe as the easement itself, and in the same way. Article 633. If the dominant estate belongs to several persons in common, the use of the easement by any one of them prevents prescription with respect to the others. And that is the end. If this audiobook has helped you, please comment down below, and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.